Welcome, everyone, to the first in our series of 7 webinars that we will be hosting over the course of this year relating to trademark practice and prosecution. Today's webinar, as I'm sure you all know, will focus on how you can expedite examination of your trademark applications in Canada. I'm pleased to introduce my co-presenter, Jamie Lynn Kraft. Jamie Lynn is a senior associate here in our Ottawa office. Jamie Lynn is an excellent trademark lawyer, and she handles all aspects of Canadian trademark law and practice, including prosecutions, cancellation proceedings, oppositions, enforcement. If it relates to trademarks, she handles it. My name is Philip Lappin. I'm a partner also here in our Ottawa office, and I also handle all areas of trademark law and practice. Smart & Biggar, as you may know, is the largest IP boutique in Canada. We handle all areas of intellectual property law and practice, including trademark and patent prosecution, enforcement, oppositions, cancellation proceedings, portfolio management, and litigation. We have experts in every area of intellectual property. If you have an intellectual property issue, we have an expert who can help you. Here's an overview of today's talk. So the Trademarks Office is in a state of crisis. We will explain how we got here. We're going to tell you how the crisis has affected delays at the Trademarks Office. We're going to give you a sense of some initiatives the Trademarks Office is taking to combat the crisis. And then we're going to focus, of course, today on all of the options available to expedite examination of your application. Our formal presentation will last just over 30 minutes. There will be plenty of time at the end for your questions. Please feel free to ask questions at any time. You do not need to wait until the end. To ask a question, you can see near the bottom of your window, there's a Q&A box. Just click the Q&A box and ask your question. Please do not ask questions in the chat box. All questions should be in the Q&A box. Today's webinar is being recorded, and following the presentation, you will receive an email with so you can replay the webinar at any time, and you will also receive a copy of the slides that you will be seeing today. And finally, at the end of the presentation, we will be encouraging you to submit a survey. If you have time, we really appreciate any comments you can provide so that we can be sure to give you exactly what you want for any forthcoming webinars. So the Trademarks Office is in a state of crisis. We know it, you know it, the Trademarks Office knows it. So how did we get here? Well, the Trademarks Office likes to describe this as the perfect storm of events. So there are 3 main events that have contributed to the crisis we're in now. So first, there was the change to our Trademarks Act in 2019. It was a complete overhaul, which changed both procedurally how trademark applications are handled, but also substantively. So everybody had to be retrained. This inevitably led to delays and inefficiencies. Also in 2019, Canada acceded to the Madrid Protocol. So this required the office to set up a whole new division with a set of examiners had to be completely trained from scratch to learn the Madrid Protocol system, which I'm sure, as most of you know, is complicated. So that inevitably led to inefficiencies. As any country does when they're about to accede to the Madrid Protocol, the Canadian Trademarks Office researched extensively to try and figure out how many new applications they could expect through Madrid designations. Fortunately or unfortunately, the Trademarks Office, and in fact, the rest of the world, did not anticipate how popular Canada would be. It was shocking, in fact, to everybody. Last year, apparently, Canada was either the number 3 or number 4 most popular jurisdiction in the world for Madrid designations. So although that's great for Canada, it meant the Trademarks Office simply wasn't prepared for the flood of incoming applications. And finally, there was the pandemic, which of course nobody predicted. And this was really a problem for nationally filed applications because the Trademarks Office for nationally filed applications is still paper-based. The Trademarks Office is located in the province of Quebec. Quebec had several lockdowns during the pandemic. During the lockdowns, employees of the Trademarks Office were not allowed to go into the Trademarks Office. And because the Trademarks Office is paper-based, this was devastating. So this meant that the Trademarks Office couldn't print examiners' reports, they couldn't stuff them into envelopes, and they couldn't mail them. So the whole process was backlogged. And because of the combination of these three events, the backlog has become huge. The Trademarks Office is in a crisis. How bad is the crisis? Well, you can see from the backlog, Canada. In fact, I think the Canadian Trademarks Office is the slowest trademarks office in the world. It's not a distinction we're proud of, but we're working our way through. So there are two tracks for obtaining trademark registrations in Canada. One track is for nationally filed applications. And for those applications, the delay from filing to examination is about 38 or 39 months. So more than 3 years. It's obviously a very long time. For Madrid designations, the delay from filing to examination is just under 18 months. And for all of you out there who practice with respect to Madrid applications, you'll know why the delay is less than 18 months. It's because the protocol forces countries to examine within 18 months. But there's no free lunch. So if you file a Madrid designation, it will be examined in just under 18 months. But if there's a provisional refusal and you file a response, then subsequent examination is of course required. Subsequent examination for Madrid designations is exceptionally slow and much slower than for nationally filed applications. So as I said, there's no free lunch. Regardless which track you choose, there will be significant delays. So what is the Trademarks Office doing to try and resolve the crisis? Well, they're taking it very seriously, and they have several initiatives that they're pursuing. Here's a highlight of some of the more important ones. So the most serious problem is that there's simply not enough trained examiners. If there were enough trained examiners, that would resolve the issues. Now, ideally, what they would do is they would just hire the 200 trained examiners. That would resolve the problem, but they can't do that because new examiners are trained by current examiners, and you can't have all the current examiners training because then nobody would be examining. So what the Trademarks Office is doing is 2 or 3 times a year, they'll have a new cohort of examiners who will be trained. And I believe it takes about 6 or 9 months to train each cohort. And then they're going to continue training these small cohorts over time. I think it'll take a couple of years before they have the number that they want. So that's a long and slow process. Another initiative which is important is, as I mentioned, nationally filed applications are still paper-based. So the Trademarks Office is digitizing those files, but that's a long and slow process. I'm not aware of any time frame that they've given for completing this process. I don't think they're anticipating that the digitization process will be completed anytime soon. The Trademarks Office is increasing the number of applications it examines each year, and they're increasing the number quite substantially. But unfortunately, the number of applications being examined is in any given time frame is less than the number of new applications being filed. So the backlog is still increasing, unfortunately. The Trademarks Office has added some online e-service tools, so that's good. But unfortunately, none of those tools relates to prosecution or examination. So those tools aren't helping with the backlog. The Trademarks Office does publish a document which it calls the Goods and Services Manual. This is on the website of the Trademarks Office, so I'll be providing the link soon. And the Goods and Services Manual has a list of about 100,000 pre-approved terms. And for any of you who have filed applications in Canada, you will know that most of the objections relates to descriptions of goods and services. I believe Canada has the most specific requirements for goods and services in the world. And so this is annoying to many applicants, but it's also a burden to the Trademarks Office. So they want to encourage people to use the pre-approved terms from the Goods and Services Manual in their application. And in fact, they're in the process of sending a letter to every applicant of an unexamined nationally filed application to encourage them to use the pre-approved list. And finally, the Trademarks Office has hired an outside consultant to come in, look at how the Trademarks Office organizes all its processes, and the consultant will prepare a final report, which will hopefully identify areas where efficiencies can be gained. To my knowledge, the final report has not yet issued, but hopefully it will be helpful. So I will now give you a brief recent history of expedited prosecution in Canada. If you go back about 15 years, the Canadian Trademarks Office was quite slow compared to other trademark offices around the world. It wasn't nearly as slow as today, but it was slow compared to other offices around the world. And so at that time, they decided it was necessary to introduce some scenarios where they would permit expedited prosecution. And so that went on for a few years, 2 or 3 maybe, and then prosecution times decreased and the Trademarks Office decided it was no longer necessary to have expedited prosecution. And so they removed all options for expedited prosecution about 12 or 13 years ago. But now, of course, the situation has gotten worse, and the Trademarks Office recognizes that there should be some options for expediting applications. So in the end of 2020, they introduced one scenario where they would allow expedited prosecution. And then in May of last year, they introduced some other scenarios where they would permit expedited prosecution. So there are 2 types of options where expedited prosecution is permitted in Canada. Jamie Lynn is now going to describe the first set of options. Go ahead, Jamie Lynn.
Thanks, Philip. Yes, so the first practice notice, which came out for expedited examination in late 2020, was for applications listing goods or services relating to the prevention, diagnosis, treatment, or cure of COVID-19. Now, the application can list other goods or services, so long as it includes at least one of the goods or services mentioned in the practice notice relating to COVID-19, and as shown on this slide, then it's eligible for expedited examination. If we go to the next slide, we'll see that being eligible is not enough. The applicant must meet one of the specific criteria set out in the practice notice and shown here on this slide. I'll mention the first 2 only briefly now, since they're the same or very similar to the criteria available to other non-COVID-19 applications. And we're going to discuss those in just a few slides. It's the last criterion here, which is specific to COVID-19 cases. And that's where there's been an approval for the use of the goods or services listed in the application that has been submitted to or obtained from Health Canada. So in that case, the applicant doesn't need to show that a court action is underway or that they're combating counterfeit products at the Canadian border in order to get expedited examination. And since the situations where this practice notice will apply are quite specific and the criteria are fairly straightforward, I'm going to leave the discussion on the COVID-19 expedited examination practice notice here, but I welcome any questions you might have about it. But for now, let's turn to the next slide and look at the second practice notice, which is for expedited examination open to any application, regardless of the goods or services listed in it. For the request to be granted, the applicant must meet one of the specific criteria set out in the practice notice and shown here on this slide. So the first 2 criteria, as I mentioned, are similar, if not the same as those on the previous slide. So that being a court action is expected or underway in Canada. Note the difference here with expected being added. And 2, the applicant is in the process of combating counterfeit products at the Canadian border. I should say or, so either one of these criteria would be enough. So with respect to the court action being expected or underway, an example of a suitable reason might be, for example, that the applicant has identified conduct which infringes its common law trademark rights. It sent a letter to the infringer demanding that such conduct ceases, and that the applicant is expected to commence a court action if the conduct continues. And based on our recent experiences, that fact scenario, something along those lines, would be likely to merit a request for expedited examination being granted. Regarding combating counterfeit products at the Canadian border, an example of a suitable reason might be that the applicant is aware of counterfeit products bearing the trademark in question being imported into Canada, and the applicant requires a registration in order to file a request for assistance with the Canadian Border Services Agency. And of course, if you do that, then the CBSA will flag those suspicious imports and let you know about it. But you need to have a registration in order to file that request for assistance. It would likely not be enough for the applicant to simply desire to file a request for assistance. They'd have to provide some conduct as to the jeopardy or risk of the applicant not being able to file a request for assistance, such as knowledge of actual counterfeits having been imported into Canada. The third criterion on this slide is that the applicant requires registration of its trademark in order to protect its intellectual property rights from being severely disadvantaged on online marketplaces. So what does that mean? Well, an example of a suitable reason might be that the applicant has identified the sale of infringing products on a website like Amazon.ca. And the applicant requires a registration in order to join the Amazon brand registry, which should enable the applicant to disable the infringing seller accounts. Now, the third criteria, it seems like it could be open to different interpretations. For example, what is an online marketplace? Does that only include websites like Amazon and Alibaba and the like? Well, based on our experiences, not necessarily. It could be, for example, a standalone online store selling infringing products. In that case, the applicant might require a registration to file a takedown request with the online store's internet service provider. Again, the applicant should explain how its IP rights would be severely disadvantaged without a registration. It would likely not be enough to simply say that the applicant wants to get on the Amazon brand registry to prevent theoretical future infringement. The fourth criteria I'll touch upon only briefly, since it's an exceedingly rare case. It's where an applicant requires a registration to preserve a priority claim in a foreign jurisdiction. So apparently, I believe it's the Philippines has this requirement. And so if you filed an application in the Philippines, claiming priority to a Canadian application, the Philippines might request a copy of the Canadian registration in order to maintain the priority claim. Again, this is a fairly rare situation, but an eligible criterion nonetheless. So let's go to the next slide. How do you file this request? Well, it must be in the form of or accompanied by an affidavit or statutory declaration, which sets out how one or more of the criteria are met. And this is for either type of expedited examination, whether it's for COVID-19 goods and services or otherwise. What does the affidavit have to say? Well, it has to provide the office with enough information to determine whether the criteria are met. Based on our experiences, the affidavits can be relatively brief with minimal details. For the cases based on some harm or infringing conduct, it has not been necessary, for example, for us to provide specimens of the infringing activity or even identify the infringer. Formalities must be observed. The affidavit or statutory declaration should be properly sworn according to local practice. So in Canada, that would mean being notarized. Only one request may be filed per application, meaning that if you want to have expedited examination on multiple applications, you have to file a separate request for each. The request must be submitted by mail or fax and not by online form. Good news is there's no government fee. Of course, there's the legal fees involved in putting your affidavit together. And it's worth noting that requests can be filed in respect of both national applications and Madrid Protocol applications. On to the next slide. What happens after you file your request? Well, currently, requests are being reviewed in about a week, and if granted, examination takes place about a week later. And if the request is granted, you won't get a letter telling you so. You'll just get your approval notice or your examiner's report. If the request is denied, then the office tells you why, and you have an opportunity to fix the deficiencies and try again if you wish. Expedited examination is very powerful because if it's granted, the application is expedited throughout prosecution, meaning that if a first examiner's report is issued, subsequent examination will take place quickly also. But it's important to note that if any deadlines are missed, or if an applicant requests an extension, the application could lose that benefit of expedited examination. Next slide. So to summarize, expedited examination is now available in Canada. Yay. And it's for applicants who have a pressing need to obtain a registration. The benefit of obtaining expedited examination is significant because it cuts the wait time down from 3 years all the way down to 2 weeks. And in our experience, the office has been willing to consider and grant these requests. With that, I'll turn it back over to you, Philip.
Thanks, Jamie Lynn. So Jamie Lynn discussed the first set of options available for expedited examination. They require a request and an affidavit. I'm now going to talk about a second type of expedited examination that does not require a request or an affidavit. Unfortunately, however, this type of accelerated examination is only available for nationally filed applications. So what this means is this option that I'm going to describe does not apply to Madrid designations. So earlier I mentioned that the Canadian Trademarks Office publishes the Goods and Services Manual. The link appears on the following slide if you want to see what that looks like. So the Goods and Services Manual has 100,000 terms which are described as a pre-approved, meaning that if you use these terms in your application, you will not receive an objection. Now, if all of the goods and services in your application are from the pre-approved list from the Goods and Services Manual, then your application will be flagged by the Trademarks Office. So let me explain how this works. So the Trademarks Office has software, and every application for a nationally filed application or an amended application that's filed is run through their software. And if all of the goods and services are in the pre-approved list from the Goods and Services Manual, then your application will be flagged. And once it's flagged as being compliant, your application will automatically be accelerated. How much is it accelerated? Well, as I mentioned earlier, for a regular application, not using the pre-approved list, the delay from filing to examination is about 38 or 39 months, so well over 3 years. If your application is flagged as being compliant, then it will be accelerated. In that case, the delay from filing to examination is down to about 22 months. Now, that's still a really long time, but it's much shorter than if it did not receive accelerated examination. In fact, this benefit is about 1.5 years. So the 2 points you should be aware of from the slide. So the first is that the delays are increasing. So this is unfortunate. So the delays are increasing by about 1 week every month. So the delays are going to get longer. But there's a benefit of having your application flagged. So I mentioned that the benefit now is 1.5 years. That benefit is going to increase. So it's going to be greater than 1.5 years as time goes on. The Trademarks Office is working hard to encourage people to have their applications flagged as being compliant with the Goods and Services Manual. Now, for those of you who are familiar with the Goods and Services Manual, you will be aware that every so often the Trademarks Office retires terms from the pre-approved list. What this means is that a term that is in the list today might be removed tomorrow. And I mentioned that the Trademarks Office requires a very specific description of each good and service. Sometimes the Trademarks Office will decide that the descriptions in the manual are not sufficiently specific and they'll retire them. So what happens if you choose terms from the Goods and Services Manual, your application is flagged as being compliant, but then 6 months from now, one of the terms is retired? Do you still benefit from accelerated examination? And the answer is yes. So fortunately, once it's flagged, it will be accelerated. And so that is, so the 2 benefits, in fact, for having all of your goods and services being compliant. So first, your application will be accelerated. Second, if a term is retired from the Goods and Services Manual, you will not receive an objection. So there are 2 benefits for the price of 1. Now, what's important, oh, and you see the link here at the bottom of this slide to the Goods and Services Manual if you want to check it out yourself. Now, I should note that, so I've just explained the benefit for having all of the goods and services from the pre-approved list. But please note that you don't have to have your descriptions from the pre-approved list. There are an infinite number of descriptions that are acceptable to the Trademarks Office, but which don't appear in the pre-approved list. So you can have acceptable terms, but the downside is if your terms are acceptable, but they're not in the pre-approved list, your application won't be accelerated. So let me give you an example to make this a little more concrete. So let's say your application only includes a single product, wheelchairs. Now, wheelchairs does appear in the pre-approved list, so your application will be flagged and it will be accelerated. So that's good. But what happens, let's say you sell wheelchairs and you also sell parts for wheelchairs. In that case, you might want a description such as wheelchairs and parts therefore. Now, this description is acceptable. You will receive no objection, but unfortunately, this description does not appear in the pre-approved list, so it will not be accelerated. So keep in mind, you don't have to choose terms from the pre-approved list, but unfortunately, in that case, your application won't be accelerated. But this leads to our final tip, which you can see on the right side of this slide. So let's say you have an application with 10 goods and services. Some are from the pre-approved list and some are not. And let's say you want to accelerate examination. What can you do? Well, since 2019, it has been possible to divide applications in Canada. There's no fee, you just make a request. And when you divide an application, you keep some of the goods and services in your parent application, and you remove the remaining goods and services in a divisional application. So in this example here, let's say we keep all of the goods and services from the pre-approved list in the parent application, and then we move all of the goods and services which are not in the pre-approved list to the divisional application. So in this example, the parent application will be flagged as being compliant, and it will receive accelerated examination. So that's great. So you will receive a registration faster for your parent application. The divisional, unfortunately, will chug along slowly, but you will be able to receive a registration faster. And there are many cases where it's important to receive a registration as soon as possible. So Jamie Lynn mentioned some of them. So if you want to sue somebody, obviously it's easier and better to sue with a registration. If you want to be on the Amazon brand registry, you need a registration. If you want to stop infringing or counterfeit products at the border, you need a registration. And if you're selling products in the province of Quebec and you don't want to have to translate your trademark into French, you need a registration. And there are many other examples where it's of benefit to have a registration. So keep this tip in mind that if not all of your goods and services are from the goods and services manual, you can still expedite an examination. You can still expedite your application for a subset if you file a divisional. Now that's the end of the prepared portion of our talk. Fortunately, we have lots of time to answer all of your questions. So I see that some questions have already come in, but it's not too late to ask new questions. So if you have questions that you haven't yet submitted to us, please hit the Q&A box, which should be near the bottom of your window, and ask questions. Now, I'm going to turn the stage back to Jamie Lynn, who will read the questions, and between the two of us, we hope to be able to answer all of your questions. Go ahead, Jamie Lynn.
Oh, thanks, Philip. And look at that. We came in under half an hour. I love it. Well done. All right. So yes, lots of questions. So the first one here, and I think some of these might already have been answered as we went along, but I'm going to ask them anyway, just to make sure that we fully answered everyone's questions. So first question, why doesn't the Trademarks Office institute a fast track for applications that limit the description of goods and services to approved terminology and charge a reduced fee for such applications? So I think Philip, you discussed that there is sort of a fast track now, but there is no fee associated with it. Do you anticipate in the future potentially a different fee structure for such applications?
So yeah, so that's a good question. And I believe they might do something like this in some countries. So the Trademarks Office does want to encourage people to use the pre-approved list. And they have thought about this option of, it probably wouldn't be charging less, it would be charged more if you don't use the pre-approved list. This requires a change to our legislation, which is complicated and has to go through various levels of government. So it's an option that they're contemplating, and I think they think it's probably a good decision, but it would be, if it happens, it would be several years down the road.
All right. Thanks. Next question. Oh, I like this one. Interesting. Would I be able to expedite the prosecution of someone else's mark so that I can oppose it? Or if I file a statement of claim and then expedite the prosecution of the other side's mark? Um, I've not considered that option before. I'm fairly certain the answer is no, because except in very limited circumstances, our regulations say that the only people who may communicate with the Trademarks Office in respect of an application are the applicant or the Canadian trademark agent if one's been appointed. I don't know, Philip, do you have any other thoughts on that question?
Yeah, no, I agree with you, Jamie Lynn. So the Trademarks Office, they're supposed to ignore any correspondence other than from the agent or the applicant, except if you file a letter of protest, which is called a notification of third-party rights. But that wouldn't be the case here. So I agree with you, Jamie Lynn.
All right. Do the goods and services in an application need to be 100% from the pre-approved list? What if there's only 70% from the pre-approved list? And I think this is relating to your last topic there, Philip. And I think you've already answered the question, but maybe for further clarity, if you wanted to confirm.
Right. Yeah. So it's all or nothing. Either all of the goods and services in your application are from the pre-approved list and your application is flagged and will be accelerated, or it won't be flagged. If you have 100 goods and services and 99 are from the pre-approved list and one is not, it will not be accelerated. But then, as I mentioned, you have the option of filing a divisional application. So you can have one application that will be accelerated and the other will not in that scenario.
All right. Next question. Oh, and this appears to be a, sort of a hypothetical fact scenario regarding requests for expedited examination. And I should say now that while I like to think that I have some experience with these, I am certainly not a trademark examiner. And I can't say whether a particular scenario would be one that is likely to receive expedited examination or not with certainty. Speaking with the Trademarks Office, I understand that each case is assessed on a case-by-case basis. But that said, I can ask this question and we can moot it potentially. Can the scenario that a court proceeding is ongoing be relied upon for the following situation? A plaintiff sues a defendant for trademark infringement. The defendant seeks to invalidate the registration being relied upon by the plaintiff for its claim. The plaintiff therefore files a fresh application to have a backup to support its action. Can that registration, so I guess the backup application, be expedited in this case? Ooh, such an interesting fact scenario. I don't know the answer to that question. The way that the practice notice is worded, it's quite broad. Simply that a court action is expected or underway relating to the trademark. I'm leaning towards that being a good reason. I don't know, Philip, if you had any comment on that particular situation.
Yeah, so it's a good question. So that sounds like you'd be using it for defensive purposes more than offensive purposes. I think the practice notice was written contemplating you would be the aggressor and not the defender. So I don't know, Jamie Lynn, but I think you're right. I think right now the Trademarks Office is leaning towards being more lenient than less lenient. So I suspect if you could describe the situation in a way that you could fit within the wording of the practice notice, that they would be probably willing to grant expedited prosecution. But like you, Jamie Lynn, I don't know for certain.
Yeah, that's an interesting one. That's an interesting one, and I think we've talked in the past about, just defensive questions about whether you can use that practice notice if you're a defendant. Interesting. All right, next question. Oh, another interesting one. Is there expedited examination after filing a request for renewal? So just to provide some context here, in Canada, we officially adopted the NIS classification in 2019 when our law changed. And so we have this entire, our entire register of trademarks prior to just before 2019 are for registrations which are unclassified. And upon renewal, applications must be classified. And you have to file a request to classify, and that request has to be reviewed and examined by a branch an examination branch of the Trademarks Office, but this is for a registration, not for a pending application. I'm fairly certain that this is not a situation where you can request expedited examination, but I can't say with 100% certainty. I'd have to go back and read the practice notice, but I think it's only for pending applications. Yeah. All right, but an interesting idea nonetheless. Next question. Can you use accelerated process if based on underlying foreign trademark application? But I think that's a request. That's more of a question for you, Philip. I think I think it's unclear to me whether the question is, for an application for Madrid Protocol or potentially just a priority claim to a foreign application.
Yes, so I don't think that scenario would make a difference. So most Canadian applications, well, I think probably most claim priority from some other application, or it's a Madrid designation. Obviously, there's a home country application or registration. So that would be considered not a relevant consideration for accelerating or expediting examination, unfortunately.
Okay. Oh, this is a question about your divisional tip, Philip. Can you move items from a parent into the divisional during prosecution if, for example, the removal will expedite allowance of the parent?
I'll read the question.
Okay.
Parent to divisional. Oh, okay. So this is a scenario where you already have a parent in a divisional, but I guess there's not a perfect division of goods and services from the pre-approved list. So let's say they're mixed up. So you have a parent and divisional. Each one has some from the pre-approved list and others that are not. So I guess the question is, can you move goods and services back and forth between the applications? Never done this. I don't see why you couldn't. You could always file a divisional of a divisional, but I don't see why. So as my understanding is, as long as you don't expand the scope of goods and services from the original application that you filed, you should be able to move goods and services back and forth. So I think the answer to your question is yes. So if you want to end up with one application only having goods and services from the pre-approved list and the other application, it doesn't matter what's there, you should be able to do that.
All right. When another question about divisionals, when dividing an application, I think I'll just rephrase the question. The question is whether there is a second fee for filing a divisional application. And I believe you answered this question already, Philip, that the answer is no, there's no additional fee for filing a divisional.
So if you have 100 goods and services in your application, you can file 100 divisional applications. There is no government fee.
Oh, here's a good question that clients ask me from time to time, and I sometimes struggle with the answer. Is it worthwhile to go back and amend previously filed marks to pull all the goods and services from the pre-approved list?
Yeah, that's a great question. So yes, so the Trademarks Office will run its software to see if your application is compliant with the pre-approved list for all existing applications, and anytime you amend, they'll also rerun it through the software. So if your application is not currently compliant and then you amend for it to be compliant, so all the goods and services as amended will come from the pre-approved list, then it will be flagged. So yes, there's a significant benefit for amending your application if you want accelerated examination.
But should you do it? That's my question. The question is is it worthwhile? I mean, certainly you get faster examination, but are you limiting the scope of your application in a way that you shouldn't?
Yeah, so that's a good question. So it depends what your goods and services are. So the Trademarks Office, the list is not as long as the Trademarks Office wants it to be. They're expanding at quite a quick rate, but there's still an infinite number of goods and services that are not probably adequately described in the goods and services manual. So I think the answer is, if the descriptions in the goods and services manual adequately cover what you're selling or want to sell, then yes, you should do it. But if what's in the goods and services manual is not adequate, then don't do it, because you're going to limit the scope of your registration.
Yeah, that makes sense. That makes sense. Right, another one here. We might have already answered this, but I'll ask it again. If I have already filed an application and it does not contain terms only from the pre-approved list, can I amend it to only have terms from the pre-approved list and thereafter receive the benefit of faster examination? The answer is yes, we've decided, yes. Whether it's filed with the pre-approved at the outset or whether it's later amended, in either case, it's going to be scanned by that software and put in the accelerated lane. I think you already answered this question as well, Philip, but we'll discuss it just so that we're completely clear. Does the description of goods or services in an application need to be exactly as found in the goods and services manual, or will minor variations that do not alter the meaning of the goods and services prevent the flagging of the application for accelerated examination?
Yeah, so sadly, if there is an added comma or an added vowel, it will not be flagged. So it's all or nothing. It either has to be exactly from the pre-approved list or your application will not be flagged. And so that is why I provided the example earlier of wheelchairs and parts therefore or parts thereof. Very often you sell a product and you want to sell replacement or repair parts. But unfortunately, once you add and parts thereof, you're no longer from the pre-approved list. Okay.
Got some more questions here. So this is about the affidavit type of expedited examination. If an applicant hasn't used their trademark in Canada yet, would they still be in a position to request expedited examination on the basis of an expected court action, combating counterfeit products at the border, or protecting IP rights on online marketplaces? So I guess this question stems from the idea that if you haven't used in Canada, do you really have any rights in Canada that are at risk? And I think that's a really good question. But at least in my experiences in filing these requests, we haven't had to prove common law rights. It doesn't seem like the Trademarks Office is requiring that level of, making a case. You don't have to say, I intend to start this court action and here is my prima facie case of trademark passing off. It seems to be very basic details are needed. I've identified infringing conduct. I intended to start a court action. Of course, an interesting question is, if you get your registration, but you still haven't started using in Canada when you launch your court action, well, our act has been further amended such that soon you're going to need to prove use of your mark in a trademark infringement action if that registration is less than 3 years old. That's not currently in force. I don't believe Philip can back me up on that one. And so there's a question of, yes, you might be able to do it, get the expedited examination, get your registration sooner, but what happens then? So it's an interesting theoretical question there. Philip, I don't know if you had any other comments on that particular scenario.
Yeah, so I don't think you need use, but it does raise an interesting question. The Trademarks Office isn't going to ask whether or not it's use. You just need to fall within the criteria set out in the practice notice. So I agree with you, Jamie Lynn. Yeah.
Right. Another question about the affidavits. Do the affidavits, statutory declarations provided to SIPO, the Trademarks Office, for expedited examination become public record? For example, could someone request a document order copy of the affidavit statutory declaration? And the answer to that is yes, it is public record. As of right now, the contents of the Trademarks Office files are not accessible online. So unlike the USPTO, for example, you can't just go online and see all the documents that have been filed, but you can file a request to the Trademarks Office for any document that has been filed against any application and receive a copy of it. So there's no really ability to protect confidential information. That said, in none of the requests that I filed have we needed to provide any confidential information. It doesn't appear that the Trademarks Office is looking for that level of detail. All right. Next question. Again, this is very similar to a question we've already answered. What if it's a synonymous good or service that you have in your application versus what's in the manual? Will that be accelerated? So if you haven't said wheelchair, but you've said movable chair mounted on large wheels, well, I think it's the same case. This is artificial intelligence that is reviewing these applications word for word to see if they comply. So that wouldn't be put in the fast lane in that case. All right, so I don't see any other questions appearing. I'll give it maybe one more minute. I'll ask a question that someone had asked me a week or so ago about expedited examination. And the question surprised me, but I thought maybe our attendees would have the same question. And that is, if your request for expedited examination is granted, so this is the one where you can get examined 2 weeks. You file your application, you file your request for expedited examination, it's granted, it's examined within 2 weeks, it's approved or not approved. The question is, could a prior filed but not yet examined application be cited against your expedited examination application? And the answer to that question is yes, it could absolutely be cited. Expedited examination, while it allows you to jump the queue, it doesn't impact priority. That depends, of course, on the filing date or the priority filing date. So even if a prior filed application has not been examined yet and yours has, it can still be cited against you. And with that, I think we've come to the end of all of our questions. So, Philip, shall I pass it back over to you to say our closing remarks?
Sure. Well, thanks, Jamie Lynn, and thanks to everybody who attended and asked. Those are great questions. If you have any questions following the webinar, don't hesitate to reach out to us. We're happy to answer all of your questions at any time. And with that, Jamie Lynn and I thank you for attending, and we hope to see you soon. Have a good rest of your day. Bye.
Bye.